Cardinal George Pell hoped to be a free man on August 21st, but his appeal was rejected.
Having reviewed the whole of the evidence, two of the judges of the Court of Appeal have decided that it was open to the jury to be satisfied beyond reasonable doubt that Cardinal Pell was guilty of the offences charged.
What's interesting is that not all three judges agreed, and this could be the basis for Pell's High Court appeal. Pell was sentenced to 6 years in jail this year after being found guilty of assaulting two choir boys more than 20 years ago.
But I sentence you to a total effective sentence of 6 years imprisonment.
He appealed this conviction, and three judges in the Victoria's Court of Appeal were asked to look at whether it should have been overturned on three grounds. On two of these grounds, they did not think Pell had the right to appeal. But there was one ground they thought had merit. This ground suggested the guilty verdict was unreasonable because of other evidence presented during the trial. The three judges read a 2,000-page transcript of the trial and watched videos of Pell's police interview, as well as the testimony and cross-examination of his accuser and other witnesses. Two of the judges believed the complainant was telling the truth and pointed to details that he knew about where the wine was kept and the layout of the room where the priests get changed. They did not think it was significant that the complainant was unsure of the exact date of the abuse and were not convinced by evidence that suggested the general routine of St. Patrick's Cathedral made it impossible for Pell to have been alone with the boys. Another key piece of evidence was the design of the robes that Pell was likely wearing at the time. Pell's lawyers argued that it was impossible for them to be parted in the way described by the complainant, but the judges disagreed, saying they were not as heavy or as immovable as suggested. These two judges believed the verdict was reasonable, so Pell's appeal was dismissed. There was, however, one judge who disagreed with the majority verdict and would have acquitted Pell. It is his argument that may now form the basis of a High Court challenge. The dissenting judge pointed out that the complainant's description of the robes changed from them being parted to perhaps being pulled up first. The judge also gave weight to testimony from other witnesses who said Pell greeted parishioners on the church steps after Mass and was almost never alone. He said he didn't find the complainant's evidence so compelling that the inconsistencies in his answers could be ignored. He said he had a genuine doubt that Pell was guilty. Some experts believe it will be difficult to convince the High Court to take on the case, and even if they do, a decision in Pell's favour will also be a long shot.